As I'm recording this video, the pandemic-delayed Tokyo Olympic Games are finally about to begin. And perhaps, not so coincidentally, the International Olympic Committee just won a decision for an Olympics-related domain name under the UDRP, the Uniform Domain Name Dispute Resolution Policy. Hi, it's Doug Isenberg, and the case I'm talking about here involves the domain name imaocolympic.com, which obviously contains the Olympic trademark plus the letters IMAOC, which presumably stands for International Martial Arts Olympic Committee. As this screenshot shows, the domain name was used in connection with a website for an apparent sports organization and prominently featured a set of 6 colored rings, which certainly looked to me to be similar to the famous Olympic rings. Now, in the interest of full disclosure, I should say that I did some work for the IOC, the International Olympic Committee, years ago as part of the IOC's worldwide corporate sponsorship program. And I can tell you, not that it's any secret, that the IOC is very serious about protecting the so-called Olympic movement, which obviously includes the Olympic trademark and the rings. In fact, many countries around the world have adopted legislation protecting the Olympic brand as part of the Nairobi Treaty, which was adopted in 1981 and is administered by WIPO, the same organization where the IOC filed its UDRP complaint here. In the United States, for example, the U.S. Code specifically grants exclusive rights to use the word Olympic and the 5 interlocking rings, which creates even stronger protection than is available for almost all other trademarks. Which is no surprise that the IOC filed a cybersquatting complaint under the UDRP for the domain name imaocolympic.com. In this case, according to the decision, the registrant of the domain name was an individual in Turkey. And although the website contained information about the so-called International Martial Arts Olympic Committee, the decision said that the website also contained some links that redirected users to adult dating pages. Now, the registrant of the domain name did not file a response to the IOC's complaint, so it's impossible to know exactly what was going on here. But the UDRP panel found this to be a pretty straightforward case. On the first element of the UDRP, the panel wrote that the Olympic trademark was recognizable within the disputed domain name, and the additional letters, IMAOC, did nothing to avoid a finding of confusing similarity. On the second element of the UDRP, the panel wrote that the IOC had made out a prima facie case that the registrant had no rights or legitimate interests because there was no indication that the registrant had permission to use the Olympic trademark or was known by the domain name, and the registrant's use of the domain name carried a risk of implied affiliation or association with the IOC. And finally, here's what the panel said about the third element of the UDRP. After having reviewed the complainant's screenshots of the website linked to the disputed domain name, the panel is convinced that the respondent has intentionally registered the disputed domain name comprising the Olympic trademark in order to generate traffic to its own website. The panel notes that the respondent has not published any visible disclaimer on the website linked to the disputed domain name to explain that there is no existing relationship between the respondent and the complainant. Quite the opposite. The prominent use of a logo, which is confusingly similar to the complainant's Olympic rings trademark and the nature of the disputed domain name, is, in view of the panel, sufficient evidence that the respondent intentionally tries to attract, for commercial or other illegitimate gain, internet users to its website by creating a likelihood of confusion with the complainant and its Olympic trademark as to the source, sponsorship, affiliation, or endorsement of its website. In other words, the panel found that the domain name was registered and used in bad faith and therefore ordered it transferred to the IOC. Now, this is certainly not the first time that the IOC has gone after a cyber squatter under the UDRP. I located about a dozen UDRP cases that the IOC and various Olympic committees have filed through the years involving such domain names as USOlympicStore.com, CanadaOlympicHockey.com, and OlympicMuseum.org. All of the UDRP cases have resulted in decisions ordering transfers of the disputed domain names, which isn't at all surprising, although I am surprised that more Olympic complaints have not been filed. I doubt that's because cyber squatters are avoiding the Olympic brand, but instead probably because the IOC is simply not prioritizing this issue. While that's understandable, especially given everything the IOC has had to deal with this past year in rescheduling the Tokyo Games as a result of COVID-19, it seems a bit short-sighted to me. The IOC, like all trademark owners, should recognize that cyber squatters damage their brand and confuse consumers. Being proactive by filing UDRP complaints where appropriate is a very simple and an incredibly helpful way to protect trademarks and the internet users who depend on them, even if those trademarks are not nearly as famous as the Olympic brand. If you want to learn more about the UDRP, please check out my masterclass on domain name disputes, as well as other resources on my GigaLaw website. And be sure to subscribe to the GigaLaw YouTube channel to be notified of future videos discussing other UDRP cases. Thanks for watching, and see you next time online.